thought it's important to say that we really, as an organization, for ourselves and also on behalf of our clients, want to express huge appreciation to everybody who's been part of this journey. So I'm not going to go into the case details. There are much more informed and qualified people to do that. All that I wanted to really stress is that the Legal Resources Center takes on cases and tries to craft cases in conjunction with our clients in a manner that can maximize impact for a much wider range of people. And I believe we've managed to do this in terms of silicosis. We reached a settlement, but that settlement is one that we reached that not only was in our view, providing a level of closure, as I say, for our existing clients, but for us was based on a case that we believe has got an important role to play in sending out signals, but also in laying a foundation for the class action that we are currently engaged in. And so, as I say, the good news is that 10 years on, we can say that we have closure. The bad news is that there are many, many battles still to fight. And we hope that you will, in the course of our working together and in the course of this interaction, be looking at what some of those issues are and be giving us the necessary kind of insights and engagements that will make what we've done and what we will be doing with other colleagues all the more potent.
If I can just give you a brief summary of the program, and that I'll just give a background of the case. Then Professor Tony Davis will come and talk about the disease, what is silicosis, and the impact of silicosis. As I said, two of our clients were supposed to be here, could not make it, so I will then read out a few of their quotes from the many statements that we managed to get from them throughout our consultations while litigating this case. And then from there on, we'll move on to Advocate Richard Moultrie, who will talk about basically the legal issues that we had to face during the 10 years. And Georgina will talk about moving forward. Now, as Janet said, we have started with a class action. We're working together, the Legal Resources Center is working together with British School attorneys and Charles Abraham Kivitz. My apologies if I pronounced that wrong. Okay, so let me just give you a background about this case that the Legal Resources Center has been involved in. The clients that we got came from the different areas in South Africa. We had a number of clients from the Free State, some clients from the Eastern Cape, and the last batch of clients came from Lesotho. All of them worked in Anglo-American mines, Anglo-American gold mines, between 1970 to 2000, between 1970 to 2000. And all of them were diagnosed with silicosis. All of them have no formal education. Very few could read and very few could write. As I said, they were all diagnosed with silicosis, but the majority of them didn't understand what this disease entailed and how it would affect their lives, and how them living their lives after leaving the mines, what basically that would mean, having this disease. As I said, they all come from the Free State, Eastern Cape, and Lesotho, and they come from rural areas. So these areas do not have any medical facilities, and at the same time, while they would have left the mines that they worked for, very few we also found did not even know that they had a right to claim in terms of Odimo for compensation. So you find that they're there, basically destitute, they cannot work, they're physically, they're no longer as strong as they used to be. They used to be the breadwinner, but after being sent home, they just basically find themselves, they become a burden to their family. So we started this case in 2004. And by saying we, the Legal Resources Center joined up with a UK-based law firm called Lee Day and Company. One of their senior partners, Richard Muir, was a consultant for this case. And he worked with us from the beginning of the case. The Legal Resources Center took up the case because Legal Aid South Africa offered to fund this litigation. As you can imagine, there are very few law firms out there that are basically willing to go against a mining company as big as Anglo-American. And you need basically all the resources that you can get and expertise to do so. So these 10 years that we have been involved in this case, together with the help of Legal Aid South Africa and Lee Day. So in 2004, we issued what I would call the first batch of summons. We represented about 7 clients at that time. And then later on, as the case progressed, we issued summons 2 other times. So the time in 2007 and 2008, and the last batch was issued in 2009. So by the end of 2009, we had 24 clients altogether. And we said that the aim of these 24 clients was for their cases to be test cases for all former gold miners who had contracted silicosis. So the idea was that should this case get finalized, it will basically affect all future claims of silicotic miners. Now, the work going forward, if you would know, let's just give an example. If you want to sue someone, usually in a civil matter, let's say I'm involved in an accident, let's say I'm walking down the street and somebody knocks me over and I'm rushed to the hospital and now I want to sue for damages. I would be the one that usually would go to the police station to give a statement at the police station, and I would have my medical records, and I would try and get as much details as I can about the driver who knocked me over and who was the owner of the car. So usually when I would like to institute a case, I would go with this documentation to my lawyer and say, listen here, I was involved in a car accident and this is the information I have. As I said, the clients that we represent, majority of them couldn't even read nor write. They had grade 2s and some had grade 5s, others had not even gone to school. So when we instituted this case, the amount of information that we had was quite limited. We tried to get as much as we could from the Department of Minerals and Energy at the time, but the way we formulated it was dependent or was based on the paper work or the documents that we got, and that was quite limited. So it was favorable for all parties at the beginning of the case to reach an agreement on discovery, further particulars, and medical evidence. Specifically with regards to discovery, that basically means that the other side provides you with documents that they think may be useful or they intend on using in the case. Now this discovery process basically started in 2006 and it ended in 2011, beginning of 2011. We were served with 250,000 documents to go through. And as we're served with those documents, that is how I can actually say that we basically amended our papers as and when we built up our case, depending on the documents that we got. So the last batch of our amended papers was served in 2011, in April 2011. Throughout the case, we always had hiccups here and there. We were taken to court, or we went to court. With 3 what we call interlocutory applications. And these are basically applications that are lodged while the case is running. And the case cannot proceed until whatever hiccup has come up, whatever issue needs to be decided. That needs to be decided first before the case can proceed. But anyway, so we had 3 interlocutory applications. There was one in 2005 where Anglo-American came up and said that, and this is right at the beginning, the year after we launched the first batch of summons, They said that our particulars of claim were too vague, they were too embarrassing, we're not making out our case properly, they didn't know what our case really was, therefore they applied for summons to be struck up. Fortunately, they didn't get exactly what they wanted, but we were told that we need to amend our papers and we should do so within 30 days after we received documents from Anglo. In 2007, there was another interlocutory application where Anglo applied to court saying that they wanted to compel us to give them what they called full, proper, and adequate answers. They had served us with requests for the particulars, and they felt that our answers to their questions were not good enough. But then again, Craigler was the one who handled the judgment. He ordered that we do provide further particulars, but he acknowledged the difficulty faced by the plaintiff, which is us, on the level of detail that was sought from their questions. And then the last one was in 2013, where we requested Anglo to give us basically better answers in 2013. So we had those three interlocutory applications throughout the running of the case. The arbitration, the summons were issued, or we started the case in the South Gauteng High Court. In September 2012, both parties sat down and decided, that is Anglo and our side, decided that the best way, because it is taking quite a while to run this case, by 2012, that had been 8 years. And we had clients on our side with deteriorating health, and at the time, we had about 6 clients who had already died after the case had started. So we felt from our side that arbitrating was going to fast track the finalization of the case, and Anglo on their side felt that the best thing for themselves would actually be to try and finalize this case outside court, so that for them, I'm sure the element of speaking. All right. So then, when we signed the arbitration agreement, we had appointed 3 arbitrators. And the arbitrators was Noble, was the former Chief Justice, and then Farlam, who's currently the Americano Commission, and Judge Hirsch, who's based here in Cape Town. So that was in September 2012. Can I also say that this case, the legal team in this case, as I said, that the Legal Resources Center worked with Lee Day from UK, but the local South African lawyers, it was basically a team of 11 lawyers made up of attorneys and advocates. And in the UK, they had a team of 6 people working on this case. So all in all was just below 20. And we had, from the beginning of the case to the end, we had appointed about 17 experts in the case. So last year September, we reached settlement. An offer was made, which we believe was a very good offer for our clients. We advised our clients that this is a good offer, and they happily accepted it. The terms of the offer are confidential, so I cannot come and tell you like how much money the clients got, but I can tell you that our clients are very happy. We can say that as the LRC, we still believe that we had a strong case, even though the matter settled. And can also mention that while after the settlement, Absa Trust came to the party and they assisted our clients in opening bank accounts and giving them financial advice. So that is just a background from the beginning to the end, but we're going to go into more detail now because I have not mentioned about exactly what our case was. So Walter will talk about that, but before we get into what is it that we allege that Anglo did wrong, as I said, what is it that we're claiming, I'm going to call Professor Tony Davis to come up. Professor Tony Davis is a former director of the National Institute of Occupational Health. He has institutional knowledge of discussions and decisions that were occurring in the industry during the time that our clients were working for Anglo, and he is going to tell us more about the disease.
The social consequence of uncontrolled silica exposure is an epidemic of tuberculosis. And this has been true since Frederick Engels wrote his classic book on the condition of the British working class. In fact, I believe that silicosis is one of the major determinants of the condition of the working class. And I also think it's high time we did something much more serious now that we have a platform. And that's what the 10-year case has established, is a platform for us to go forward. Silicosis is a disease of workers in dusty trades exposed to dust containing silica. And the silica we're talking about is identical chemically with the sand on the beaches around the Cape coast. And the tiny particles, much smaller than the grains of sand on the seashore, produced by grinding, cutting, drilling and blasting and other high-speed, high-energy input processes, get suspended in the air and inhaled into the depths of the lung. And there they lead to progressive scarring. And I think perhaps this should come first, and to an impairment on the first line of defense in the lung against inhaled particles, the scavenger cells or macrophages. And this leads to a greatly increased propensity to get tuberculosis, right? And therefore to my epidemic of tuberculosis. The combination of silicosis and tuberculosis is particularly damaging, and it limits physical exertion, it shortens life, and it poses a communicable disease threat to the family back home, or the community back home, or to fellow workers. It's a very serious situation. I have culled the two studies of the returnees to Lesotho who were studied by the Aurum Health Research Institute. And I've taken out key points from the two rounds of examination which were done on that cohort of miners. I think it's a disaster. I have 50 copies, which you're welcome to take away and study. It's important that we reach agreement about how serious this is. If you are a dissenting voice, you must tell me, because I want to listen to you. So, silicosis is eminently preventable. You wouldn't believe it to listen to the big companies. It's eminently preventable, and it has been successfully prevented in many countries. And you can read iconic accounts of the prevention of silicosis among granite cutters in Vermont, among miners in Western Australia. We had a new case of silicosis in a worker that began work after 1979. It's a fantastic achievement, even if it's only half right. But so if they can do it, why can't we do it? We can't do it because the causes of disease, as Virchow said, are as much social as they are medical. And Virchow was absolutely right. If he'd been here today, he would have said, I told you so. The way our country is organized, with huge dominant conglomerates, very powerful at the ear of government, means it's very difficult for advocates of change to get anywhere at all. For more than 100 years, the government, industry, scientists and health professionals have been told repeatedly that it is essential to control dust in the mines if you are going to control silicosis and tuberculosis. There are a number of reports. Interestingly, progress was being made prior to 1949. And since then, we've gone from bad to worse. South Africa has been unable to control tuberculosis, notably in the Cape Province, right? And in the wealthiest areas of the country. If you read the recent studies of Cape Town and the tuberculin test conversion rates, you will see that we're dealing in the Cape with a forceful epidemic, at least as strong, I think, as the one which has rendered prophylactic isoniazid, or even louder. Okay. We need, so we've been unable to control tuberculosis, partly because we have so many people exposed to silica, I'm sure. So, in the mines, we now have a conjoint epidemic of silicosis and tuberculosis, which has broken all of the world records. I hope that with the exhibition of antiretrovirals, TB is perhaps going to turn a corner. There's no change in the dust levels in the mines, as far as I know, right? But two things have happened in the courts. Well, two things have happened. One is that happened in the courts, which has legitimized legal action. So we don't have the problem that we started off with from the Cape case, and raw chemicals, and then after that with the silica case. The other thing that's happened is that in the medical press, and this is the study of the Lesotho miners, which I mentioned earlier. And in order to understand that epidemic and the figures which have been produced over the years, you have to realize, I think, that all of these diseases, silicosis, tuberculosis, and HIV, people take some ARVs, are progressive diseases. The prevalence in working miners and ex-miners who've left the mines recently and ex-miners who've left quite a long time ago are almost identical. My understanding of this epidemic is that death, which may be 10 times that of British men of the same age range, right, as our miners, is causing a rapid exit from the cohort, but progression of disease, in particular the superimposition of TB on silicosis, is replacing the prevalence, which is now, I think, almost static.
I'm going to use the miners for what they were worth, and when they were of no use anymore, they threw them away. That's just one of the reports I have here. And another time who said that he overestimated his strength when he, a few years, I think about 6-7 years after he left the mine, he was at one point was on his way home, and then it just started raining. He said he could actually see his house, which was about 100-200 meters away. So when it started pouring, he's like, okay, let me just run to rush to get shelter. While running, he collapsed. He collapsed and he had to be rushed to the hospital. So his words were, one of the quotes that I have from here is that he says, I saw my illness as a disability because I couldn't work for the rest of my life.
We have been seeking a way to make these very real things come through in a way which this edifice that is the law can understand, to make it meaningful through that process. And it also strikes me that what I'm going to talk about is simply to give you information about how we have tried to do that up till now. It's a bit like talking about one of those old brick cell phones compared to an iPad or an iPhone. That was silicosis litigation 1.0. I think that what the next speaker is going to be talking about is silicosis litigation 2.0 or 3.0. But it's really important, I think, that I first, and that you know where we've come from, and in a sense that I just convey that information as clearly as I possibly can. I do feel like I've been given a bit of an unfair task here, because I was told to talk about the legal aspects of the case, but I was also told not to talk legally, like a lawyer. So I'm going to do my best to try and explain some of the legal aspects of the case as we have understood it up till now, because I do get the sense that we're on a cusp, and this case is emerging, it's changing, and it's going to become something quite different to what it's been up till now. And I think that's quite an exciting moment. I can also say that, I suppose, with the level of detachment, because although I have been involved in the case for 10 years, I am no longer. So in a sense, I can look back and see what we've done, and then look forward with excitement, and maybe hand the baton on a little bit to those who are still involved. The most important thing to understand about this case so far, which is perhaps unfortunate, is that it's a damages case. It's about money. The case that we have been running so far, on its surface, has had nothing to do at all with changing the way that mines mine, at least not directly. And I'm going to say something at the end of what I want to say now about how we must think about that, because the law as it stands gives us this platform, which is a damages claim, to make the mining company pay the miners some money. But I'm not certain that that is the way in which change is going to be produced. And it's not necessarily the way that we can change the way that mining operates. And I'm just going to put that out there, but describe where we've come to so far. The claim for damages in South African law is known as a claim under the law of delict. As a plaintiff, you have to prove 5 key elements. You have to say what your defendant did or didn't do, an act or omission. You have to show that it caused you, it's a causation element, harm of some kind. And fundamentally that harm in this case is the harm that people suffer from silicosis. But the way the law sees it is that it views that harm through a financial lens. So that harm is, yes, I've got sick, but it's my medical costs, my loss of income, the fact that I won't be able to work in the future. And there's a very little, small amount that the law adds on for pain and suffering and for the sheer indignity of having been subjected to this industry, and to which you have given your labor for very little in return, and which has destroyed your health. That's the harm. And you want to show this loss in monetary terms. But in the process, you have to show that what your defendant did, or the way your defendant did these things, was negligent and it was wrongful. Now, as a lawyer, those 5 elements are the way that we view this case, and I'm going to try and bring those alive a little bit, if I possibly can, to describe some of the challenges that we faced in showing those 5 elements. I should say that the difficult aspects of this case were not legal. It's not a legally ground-breaking case. This is not, for example, a case in which we are trying to pierce the corporate veil and show legally that a parent company is liable technically for the acts of its subsidiary company. There are some legal complexities in this case, but the real complexities are factual, and they have to do with showing what the mining industry has in fact been doing for this very long period that we're talking about, from about 1960 to about 2000. And it's much more difficult than you might first believe, to actually know what they did and how and in what way, and then to show that they did so negligently. So, who did we sue? Well, and for what? And I think that the context of this case has to be first viewed, when we first launched it in the context of the mining house structure that exists in South African gold mining, or did exist then. Some of you may know that traditionally what happened was that you had these large mining houses, of which Anglo-American was but one. There were about 4 or 5 over time. And there were subsidiary companies which the mining house, or let's call it the holding company, didn't always own 100%. But those companies were the mining companies, and they employed the individual workers. And when this case was launched, and it is still the case now, those companies, by and large, simply no longer existed. Those companies that employed the people went into liquidation, were taken over, were closed down some time ago. They were closed down mostly in the 1990s, and that was as a process of the financial restructuring of the mining industry that happened. So the question was, well, who are we going to sue? Because we know this is what happened in the past, but what had happened by the time we started running this case was that the mining industry had fundamentally changed. And there was another difficulty, and it was this. There is a law that says that you may not sue your employer for damages that you've suffered at work. And the reason for that is that there are statutory insurance schemes, compensation schemes. There's one in the mining industry, and there's one more generally for all employees in the country. And the Constitutional Court, in a case called Score Supermarkets versus USTA, had upheld this ban on suing your own employer for damages suffered at work. So even if we could find a mining company which was our client's employer to sue, we couldn't sue them, or at least we took the view legally that we couldn't sue them. And so we had to come up with some kind of a creative way in which we could find a way of getting compensation for our clients. And the rather creative way that was thought up, and is totally valid, is that because of the mining house structure, the way that the mining houses used to extract their profits from the mining companies was through a set of service agreements. So instead of taking dividends from their subsidiary companies, effectively they would perform services through service agreements, and the mining companies would pay the holding companies a fee. The precise reasons for that historically are probably quite complex. They may have to do with tax structuring at the time. But basically what we realized was that because of the fact that the mining companies, or the holding companies, were giving advice to these mining companies, we could sue them on the basis they were giving negligent advice, and they had a duty of care to the employees, whose employers they were giving advice to. That was the reason initially why we launched that case in that way. It has to be said that our view on that has changed as a result of the Mankai case, which Richard Spoor took to the Constitutional Court, and which actually resulted in a situation where we understood that you can now sue an employer, and more importantly, its holding company directly for damages suffered at work. So, what did we say that they had done? The claim that we ultimately had after all of the amendments that Sai talked about was a series of direct actions which had caused the silicosis, and a series of omissions which, but for which, or let's put it this way, if the mining companies had not omitted to mine safely, we said the miners would not have suffered the silicosis that they suffered. Dust causes silicosis. We said that if they had kept the dust levels below a certain level, by far the majority of the miners would not have got silicosis. And we still say that. And I think Tony points out that countries all over the world have managed to keep their dust levels below a certain level, and miners don't get silicosis. So the question is, well, what were the dust levels? And we ran into this quite extraordinary thing. It was a historical anomaly, if I might put it that way. The mining companies, for 40 years, didn't measure the dust in their mines, if you can believe that. Well, they didn't measure the dust for the purposes of seeing what effect it would have on their miners. What they did do is they came up with some kind of a strange proxy. It's a machine, a big heavy machine, and was invented by an inspector of mines back in the 1920s. And it's known as the kinemeter. And what it does is it sucks in a bit of air and it shoots a bit of dust onto a prepared slide. And then they count the bits of dust on it. And then they say, well, this mine has got 200 particles of dust per cubic centimeter of air. But that has absolutely no bearing whatsoever, or no relationship whatsoever, to the amount of dust that a miner breathes in. So you ask, well, why did they do that? And they did it obsessively. Hundreds and thousands and hundreds and thousands of these measurements that they went down mines, taking these measurements to say, this is how dusty that mine is. But they weren't interested in the health of the miners. I don't think that they were interested in the health of the miners. What they were interested in was who would pay for the compensation scheme. Because the compensation scheme was designed in such a way that whatever measurement you got as a mine with your kinemeter, if you got high dust counts, then you had to pay more. And if you got low dust counts, you had to pay less. And so it was just simply a method of working out who would contribute how much to this scheme, which it has to be said, nobody got any serious compensation from at the end of the day anyway. So Anglo-American came to us with 250,000 documents, which we read and we pored over and we read and we read and we read, but we couldn't find out how dusty the mine was.
Moving on to why we are pursuing a class action in this case. As has been highlighted by Sai and some of the other speakers tonight, the gold mines recruited for their look-for mine workers throughout the Southern African region. So extensively in the Eastern Cape, but then also Lesotho, Swaziland, Mozambique, even as far as Malawi, Botswana. So there's a hell of a lot of people that are living not only within South Africa, but beyond our borders, who may be affected by this case, who have silicosis, who worked on the gold mines, and who will stand to fall within the class. So not only are there many people beyond our borders, but many of these people are living in very rural areas. There's little access to information, there's little access to justice, there's very little knowledge about certain rights and entitlements that former mine workers have. So one of the benefits of a class action, one of the beauties of it, of the mechanism, is that if we can certify the class, if we get a court to agree that we're allowed to proceed on behalf of this class of mine workers, class of people, we will then be allowed to advertise extensively, and anyone who falls within this class will stand to benefit from it, as opposed to having to bring a series of individual actions against former employers. So I think, so the importance of a class action, it improves access to justice.